so I get this question a lot as well from some of my friends and clients, is that when you're choosing a mediator or a mediation arbitrator, do they need to have do they need to be a lawyer? No,
No.
right? Okay, all right. Is there an advantage to picking one over another? So, I mean, there are mediator arbitrators who used to be judges, for example, or who used to be lawyers, and then there are some who are not now. What is the advantage of one over another? Laura, do you want to start?
I think it's not necessarily in terms of advantage, but I think it is about what issue is being dealt with. So if there is an issue that you may require some legal background or financial or whatever the case may be, then you may want to you may gravitate, those families or clients may gravitate towards someone who has that background. Versus psychology, or if there's a child related issue or there's addiction, trauma, all of that stuff, then some may gravitate towards someone who has a psychology degree or background or mental health background. So I think it really depends on, because the reality is, or should be anyway, what Marty had said earlier, that whether your financial background, legal background, psychology background, you have undertaken the additional arbitration course, and you do know the Arbitration Act. You're following the same the same rules, and you apply the same rules. So I'm thinking more, and Marty, correct me if I'm wrong, but I'm thinking more it's related to the issue that needs to be discussed.
Marty?
Yeah, so I think I think there are two schools of thought. I mean, in mediation, and one is directive, where people will come in and say, "Look, this is where it's at. You're gonna have to pay support. You're gonna have to do this. You're gonna have to do that," and it's like it's all set out for you. There are other schools of thought, and I think a lot of lawyers. And I do this, and I think a lot of lawyers don't like it, because I get a lot of referrals from lawyers, is where, listen, this is your life. This is your interests that are at stake. I'm not going to live tomorrow, live with you the day afterwards. I'm going to be gone, and you're going to have to live with the results of the decision you make, whether it's foisted on you or, by an arbitration or an order or whatever, or an agreement. So that's interest-based mediation, which I think that Laura and I more practice. A lot of people say that they want directive people because they want them to go in and get a response, to get an answer. But a mediator is a facilitator. We're just there as a referee, really. And so we're going to guide them, and we're going to say, okay, what about this here? And then someone says, well, I don't, and then the mediator should come in and say, okay, well, what I hear you saying is this here. It's not all that easy, what I'm saying to do, But a mediator is a facilitator. So if someone comes to me with a tax problem, this is this arbitration I'm going into, it's a big tax issue, major, like totally, and I've been out of it. They've been having all kinds of meetings with one decent, very well knowledgeable tax lawyer and an accountant, and I have not been a part of it, rightly so, because I'm the arbitrator. But you can call in people, so you're there as a facilitator. So Laura and I recently had a case that I didn't think would settle the parenting thing, and we called in a parental coordinator. Just she was the right person, and she came up with a resolution. And I mean, it was amazing. I mean, really. And I'm so pleased that that's happened. So I'm the kind of person that I like to, like in collaborative process, now the big thing in the collaborative law process is to work in teams of people, a financial person, a family representative, or I can't remember the word, independent family person, I skipped my name, the exact name, but anyhow, child consultant, that sort of thing. I always call people in if it's necessary. I find that sometimes we overstep our bounds you know, as lawyers and as judges, but especially when it comes to children, that we don't have that background,
Mm.
and it could be trouble, you know. I mean, uh, you could be making decisions in people's lives that are really bad decisions, and maybe you really do need somebody with a mental health background or whatever that background is to step in and make that decision. I know personally, I was involved in a partnership, a law office partnership breakdown, and the people we got, some people involved, 3 people, not one person had any knowledge whatsoever commercial, corporate commercial law, and there are 5 partners and 4 of us got nailed badly, and it was horrible, and no one knew anything about how to deal with it, and they should have at least said,
Mm.
look, gotta work. They were more interested in the relationships between us than they were at the bottom line, but in the bottom line it ended up after 1 year losing $75,000. So that wasn't, and it was a while ago, so it was worth probably a lot more today. So you know, the wise person, I think the wise judge calls in people. That's what I think.
Well,
The
that's what,
judge makes the decision ultimately. The arbitrator ultimately makes the
right.
decision, or the mediation that the clients do. But I think there are cases where you need to call people in.
But if an arbitrator um, feels that they don't have the expertise and they really shouldn't be deciding a certain issue because they don't have the competence, can they, out of their own initiative, call an expert? I guess this goes to the creative solution
Yeah,
question.
I think so. Yes, I do.
They're
On the
allowed, right?
proposal, yeah. Um,
I
you
think
know, I
you
remember
should.
Yeah,
there's a family there's a family law lawyer that became a judge a number of years ago, and she is now what they call supernumerary. She's sort of retired and sits, you know, so many days a year that they're allowed to Superior Court. And I remember asking her a question once, and I said, after she became a judge, and I said, how do you deal with cases like you did family law? That's all you did. Like, how
Mhm.
do you deal with these cases? And she was on an $8 million uh, case claim, that claim for $8 million medical injury claim. I think it was a malpractice claim. And she said, you know what? I just sit there and I listen to these guys who absolutely blow your mind because they know exactly what they're talking about. They give you all the case law, they give you everything in submissions, and I just make the decision based on, I apply the law to the facts. So I've got it all there. That doesn't always happen, especially in small claims court, trust me, or in mediation or arbitration. But you sometimes have to dig in and do it yourself. But so yeah.